What's up, guys? Let's talk trial. So, in this series, I've been covering the Derek Chauvin trial, the guy who's been accused of murdering George Floyd. And what I've been doing is I made a couple of videos so far, going over key portions of the trial and going over what we can learn from what we're seeing and how we can do better, how we could improve for the next trial. And in today's episode, I want to talk about the cross-examination specifically of the witness, Donald Williams, which is the guy that basically showed up at the scene when the police officer had his knee on George Floyd's neck. And he's the guy who's basically the most active in trying to stop the police officer from continuing to do what he's doing and potentially trying to save George Floyd's life. So he testifies on direct examination, and his testimony is pretty damning for the defense to the extent that he says that he could tell as a trained mixed martial artist that the officer was applying a blood choke, what he described as a blood choke, when he put his knee on George Floyd's neck. And so from his testimony on direct examination, if believed by the jury, this is basically intentional homicide. It's a murder. He's saying that the officer put his knee on Floyd and that he was, quote unquote, shimmying the choke or kind of, the way he described it, closing the gap between his knee and George's neck. And so in essence, what he's saying is that the officer knew that the quote unquote choke was not in deep enough and he was applying it deeper to basically choke George out with the intention of murdering him. And so from the defense's perspective, if the jury believes that testimony, you're going to lose that case. If the jury believes Mr. Williams, that case is over because they're going to believe that the officer basically intentionally choked George Floyd to death. So that's a problem. So that's an important witness for the defense to attack and to come after in a way that's going to negate or minimize the impact that the witness has created or has brought to the case. Now, the cross-examination had his good points and it had his not so good points. Primarily, it did not really start with anything impactful. It started with a repeat of the direct examination, and then it went down the styles of chokes and the witnesses' professional record and things like that, that frankly didn't really add a lot to the case. And so if I were to do that, let's say if we're trying a case that was just like this and you're going to do that cross-examination, the suggestion would be to start with the strongest point that you got. Typically, we start strong, we end strong, and we put everything else in the middle. And so the types of chokes and the witnesses' professional record and all that kind of stuff isn't really all that important or all that strong to begin with. Knowing that you have to challenge the witness's credibility, what you should start with is what the defense eventually got to sometime towards the middle or tail end portion of the cross-examination, which is the witness on direct kept saying that he was using controlled professionalism when he was speaking to the cops. So basically he's saying I was in control the whole time and I was being professional the whole time and this and that. But the reality is that's not what the tape shows. The tape shows that he was upset. And mind you, he should have been upset. There's a good reason to be upset if you're watching what he's watching. The important part is not whether being upset was justified or not justified. The important part is the jury's going to make a credibility finding as to the witness, basically whether you believe him or not believe him as a certain portion of the case. And if you have a witness who's on tape saying things like, you fucking bum, you bitch ass bum, you're not a real man, you're a fucking bitch, that kind of shit at the cops, then you cannot be telling the jury that you were using controlled professionalism when it was happening. You got to admit to the jury, look, I was upset. I shouldn't have said that. I said what I said, and I was upset at the time. And in my normal professional environment, when I'm a security guard, I don't really handle the situation like that. But the situation was outside of the ordinary. Somebody was getting killed in front of me, right? That's not what the witness said. The witness stuck to the idea that he was using controlled professionalism. And so if you're the defense, that's a great portion to start your cross-examination because you can show the jury that what he's saying is not completely what happened. Meaning you can show the jury that he was not acting in a professional manner. And you can ask the witness as to whether he was or wasn't acting in a professional manner, knowing that he's going to tell you that he was acting in a controlled professional manner. And so the jury can see that this witness is not being forthcoming, or that he has an angle on the case, is the reason why he doesn't want to admit that he wasn't professional and controlled, right? Now, in the grand scheme of things, it would not be a big deal. If he had come in and admitted that he got upset, that he was shouting at the cops, that it was not a professional thing to do, not a big deal. The defense can't really make any points there. The defense would not really be able to make anything out of that. But because he said the complete opposite of what you can see on the tape as to what his demeanor was, the defense can come in and actually make some big points on him. And that would be really where the cross-examination starts, because you're making a big point that goes directly to the witness's credibility. And so once you challenge the witness's credibility, then it becomes harder for the jury to believe really what else he's saying. And some of what he was saying is really subject to interpretation. Like he was saying that, you could see on the tape that he moved his foot like a, centimeter to the right or centimeter to the left or something like that. And that it indicated to him that he acknowledged the fact that he was choking George out or something like that. I think different minds, reasonable minds, could differ as to whether you can see that or not see that on the tape as to what was going on. And so if you can challenge the witness's credibility on that, you're going to make huge strides in neutralizing that witness. And so that's important. The second important thing that the cross-examination brought out and could have been brought out in a cleaner fashion is that in a blood choke, people pass out. When the choke is deep, people pass out real quick. You're not getting choked out for 9 minutes and 24 seconds. If it's a blood choke, you're going to be out. If it's 9 minutes and 24 seconds of being choked like that, you're going to be out for 9 minutes and 17 seconds of those 9 minutes and 24 seconds. Obviously, that's a big problem for the prosecution, because if their theory is that he was getting choked for 9 minutes and 24 seconds, then it cannot be a blood choke. It has to be some other type of asphyxiation, because those other types of asphyxiation would actually take a lot longer for you to pass out. You can hold your breath for like 2 minutes or a minute and a half under most circumstances. And so if you're taking shallow breaths here and there, you're potentially going to be up without passing out for way longer than that. And so maybe that would support a theory of other types of asphyxiation, whereas the blood choke theory would really not hold up too well. And so if you start with the credibility issue and get a good hit at the witness's credibility, and then you transition into the undisputed fact that a blood choke would put you out in about 5-10 seconds if properly applied, then you have done two major things that you need to accomplish with this witness, which is, number one, you need to neutralize his credibility. And number two, you need to establish a good fact for your case, or critical fact for your case, which is that this is likely not a blood choke, which I imagine is going to be supported later on by the medical evidence that the defense and the initial ME hired by the state is going to corroborate. So basically, when it comes to that witness, a cross-examination could have probably gone on for, 10 minutes tops and be pretty effective and be clean in and out. The rest of the points established by the defense, it was not really clear to me just yet why they were established or what do they mean. So I can't really comment on that just yet, but it definitely seemed kind of roundabout ways of getting to things that are not entirely all that important, or that right now they don't appear to be all that important. The last thing about the cross-examination that definitely we could take from it and use to improve is there were points in the cross-examination where the witness was not giving the lawyer what the lawyer thought the witness was going to say, and the lawyer basically would object to the answer to his own question and ask the judge to get involved and tell the witness to answer the question a certain way. Different people would differ as to whether that's good or bad. From a psychological perspective, I always felt that if you're the cross-examiner, you're in control. As a judge, obviously in the courtroom, but from the perspective of who is running the show on the cross-examination, it's got to be the lawyer. And if the lawyer's running the show, the lawyer's got to be able to control that witness however the lawyer needs to control that witness, and use different techniques to make the witness look less credible if the witness does things that you don't like. For example, answering questions in a way that have nothing to do with what you're asking, meaning i.e. non-responsive. And so instead of utilizing those techniques, the lawyer in this particular case was asking the judge to get involved and tell the witness that he's being non-responsive and to answer the question a different way, which it almost looks like, you're going to the teacher for help, right? Instead of you running the show. So different people differ as to how they feel about that. My take on it is shouldn't go to the judge. You should handle your own business in the courtroom, and you should have tools in place for you to do those things when need be. So anyway, guys, that's it for now. I'll make another video on this as I catch up with some of the other testimony. I'm going through day 2 right now of the trial. I think there's been 5 days of trial, so I got about 3 more days to go through. So I'll make another video when something strikes out as interesting or that we can talk about in some of the other trial days. So that's about it. I'll catch you again next time.